You're watching the AI report right here on News9, and now let's take you through another big development that happened in the week gone by in the world of artificial intelligence, and this one rests at the cusp of social media platforms. That's right. The government in the week gone by tightened India's IT rules to crack down on misuse of artificial intelligence on social media platforms, including X, Facebook, Instagram, as well as YouTube, mandating takedown of unlawful content within just 3 hours and compulsory labeling of all AI-generated or what is called synthetic content. The amended rules notified by the Ministry of Electronics and Information Technology responded to a surge in AI-driven deepfakes, non-consensual intimate imagery and deceptive videos impersonating individuals or fabricating real-world events. Now, the changes come into force as early as February 20th, 2026. Now, under the new framework, platforms must remove illegal content flagged by the government or courts within just 3 hours. This is down from the earlier 36-hour deadline. Now, for content involving nudity or sexually explicit content, the takedown timeline has been cut to just 2 hours. User grievance redressal timelines have also been significantly shortened. Now, intermediaries or platforms like Facebook, Instagram, X, or even YouTube are also required to deploy automated tools to prevent the circulation of illegal, deceptive, or sexually exploitative AI content, including child abuse material, impersonation, false documents, or non-consensual imagery. Moreover, these platforms must require users to declare whether content is AI generated and verify such declarations before the content gets published. Now, the rules place accountability not only on platforms but also on AI tool providers such as ChatGPT, Grok, and Gemini. Serious AI-related violations, including those involving child protection or criminal offences, must be reported to authorities. The amendments follow heightened scrutiny of generative AI after controversies around Elon Musk's own Grok, which was accused of enabling the creation of obscene and non-consensual images. Remember, earlier this year, MeitY directed X to remove unlawful content generated by the chatbot or face legal action. Now, failure to comply with the new due diligence requirements could result in platforms losing their safe harbor protection under Indian law. Now, let's put all of this into perspective. What does this mean for social media platforms? What does it mean for users of social media platforms, as well as what are the legal implications if platforms fail to comply? Kapil Chaudhary, partner at Denton's Link Legal, joins us to break down this huge development, one would call it. Kapil, thank you so much for your time. Just break it down. First up, is 3 hours enough time for for social media platforms to act on a government directive? And does the timeline of AI labeling by the 20th of February make sense from a timeline perspective?
Thank you, Karthik. And as you rightly laid the context, and thank you for inviting me on the program. So I think this change is fairly unprecedented. We've seen a dramatic shift in obligations of intermediaries, especially significantly the SSMI, the users with the platforms with more than 5 million registered users. They face the highest tier of obligations. And I think if you do like a rule by rule comparison to the previous timelines, and I'll quickly walk you through that, which is I've also served as general counsel with Twitter in my earlier roles before moving back to private practice. So this is a significant change. What it essentially means is that platforms will now have to remove or disable access to unlawful information. Earlier, the timeline was on receiving actual knowledge through a court order, which was 36 hours, or being notified by law enforcement. Now the new timeline is 3 hours. As you rightly said, if earlier the timeline for resolving user requests for removal of illegal content was 72 hours, now the new timeline is 36 hours. And similarly, the takedown requirement for images depicting a user in sexually explicit conduct, or CSAM, is from 24 hours, now it's reduced to 2 hours. Now, what this does is this raises multiple concerns, right? Firstly, this undermines legitimate speech. So what this shortened window does is it effectively eliminates the time available for contextual review and fact checking. Now,
All right.
remember, all platforms, namely Meta, the YouTubes, and the Twitters of the world, they obviously deploy, content monitoring tools. And now what's going to happen is with this shortened window, which is almost impossible to meet, they will have to prioritize speed to maintain their safe harbor protection. So
Okay.
this kind of limits a case-by-case evaluation. What
Just break down,
also
Kapil, for
is
our viewers. For our viewers, Kapil, if I can request you to break down this safe harbor protection. What is the safe harbor protection? How have social media platforms been using this safe harbor protection? And overall, take this conversation forward in terms of how users can also have their grievances redressed faster.
Absolutely, absolutely, Karthik. So, I'll give you the example of a safe harbor protection. Now, what happens is platforms which are essentially intermediaries, which is, Facebook, the YouTubes of the world, the Metas of the world, they enjoy in law what is called a safe harbor protection under Section 79 of the IT Act, which basically means that they are not responsible for the content on their platform as long as they've carried out adequate due diligence, because they are basically it's the equivalent of the intermediary as a pipeline. So they are typically like a postman who does not know what the letter contains and should be insulated from liability. Now, what the amended rules effectively now do is they're asking the postman to open the package and examine its contents and make legal determinations about its lawfulness. Now, what this does really is that this profoundly shifts the liability framework from a reactive knowledge-based liability, which is from the Sharia single case onwards, to proactive monitoring-based liability, which therefore has far-reaching implications for platform businesses as well as user rights.
All right. Now, talk to us
Now,
about the consumer angle to this, Kapil, which is absolutely critical. In case a consumer was to discover his or her image being used without consent, or potentially discovering content which is either not AI labeled or is inciting emotions which are unwarranted, what can consumers do?
Absolutely, Karthik. So, Karthik, now, every platform has what is called a grievance redressal mechanism, right?
Right.
So, to the law, the platforms are required to appoint grievance officers. They are required to be notified, and all of these channels have an intake mechanism. So, let's say if you find something offensive on YouTube or X, you're supposed to raise a complaint to the grievance officers, who will now have to obviously act within a very compressed timeline. Earlier, the time 15 days. Now the users will have 7 days to get their grievances addressed.
Okay.
Now, remember, there are also multiple other options available to users. If the platform does not redress this grievance or does not remove or disable access, you can either go and approach the court, or you can also file a complaint to MeitY. And the MeitY continuously monitors these user grievances, and they actually call the grievance officers of these platforms. There is a regular meeting which the MeitY does, and they actually call out all these cases of non-compliance. And also, the platforms are required under law to file monthly reports on how much of this content they have taken down on a month-to-month basis.
All right. Now, Kapil, I also want to, interject at this point and understand from you that what are the kind of legal consequences if platforms fail to comply, number one. And number two, are we likely to see platforms oppose this directive? Are we likely to see some litigation going forward?
Absolutely, Karthik. Great question. So some of the concerns that we've been talking to a lot of industry experts, and now what's going to happen is that this increases liability of platforms multifold, right? So earlier, while these if say, and I'll also let you know how this will play out eventually. Now, typically, if the platform is not able to meet this timeline of 3 hours or 2 hours, which is almost, as I said, impossible to meet, they get threatened by the removal of what is called the intermediary liability protection, which means they are then treated as a publisher of the offending content. Now, what their actual liability will then depend upon the nature of the content. So let's say if somebody is not removed, say, child sexual abuse material or national security content, whatever Indian law provides as punishment for those offenses the platforms theoretically become liable for that offense. But it will be on a content to content basis and it will vary in severity. I also want to point out a very important point, Karthik, which is under criminal law, the basis of liability is criminal intent or mens rea, right? Now, this raises a very fundamental question, which is once these intermediaries and these platforms, by merely failing to comply with the takedown timeline requirement, do they really have a mens rea or a criminal intent? Because that is the basis for Indian courts to apportion liability on these platforms. So, it kind of raises multiple questions, but the main impact of these rules, these amendments, is that there is a fundamental conceptual shift from the original intermediary liability paradigm itself, from a pipeline to now a content policer. So this also gives rise to issues like, there'll be difficulty in classifying edge cases, fact checking will become extremely tough, and as you know, right, in the in the post-Trump era, platforms have anyway gone soft on content monitoring.
Absolutely. Right? Fact-checking teams were fired.
Absolutely. So, this will also have a chilling effect and could even lead to over-blocking content. So, for instance, news channels and a lot of news blogs openly write satire, political commentary, culturally specific material. Now, they face the risk of automated removal because there'll be a lot of automated tools deployed because it'll be humanly impossible to monitor and take down this enormous amount of content.
All right. And my final question to you, the question has always been around regulation in artificial intelligence. Too much regulation can thwart innovation. Too much regulation can, of course, too little regulation can actually lead to deepfakes and the proliferation of content which is unwarranted. Overall, is this a step in the right direction? Regulation of AI-related content, was it warranted? And has the government really used a very, very hard hand on clampdown? Or do you think this is just the first chapter in a much larger story which is yet to play out?
Excellent question, Karthik. So let me respond to that in this manner. Look, we are just heading into one of the biggest AI events in the world, which is the India AI Summit. Global world leaders in the artificial intelligence field are going to be in Delhi. This is a unique opportunity for India, right? So I would say perhaps the timing could have been slightly better. The intent is very positive. I would say India is probably now going to be coming across, and similar legislation exists in countries like Australia and other countries as well, but the timelines are extremely stringent. So I would say regulation of AI, the entire fairness, equitable, transparency requirements are all very welcome. However, what we are probably advocating is that if the MeitY can engage in, say, some sort of a dialogue and look at a implementation timeline, say over a 6 or a 12-month period, and there is precedent for that under the EU AI Act as well.
Okay.
And also, I think platforms will be well advised to approach MeitY and seek clarifications. They have issued FAQs, but it will be important, to have multi-stakeholder coordination. Association like the UK IBC, US IBC, NASCOM, ASSOCHAM, IMAI, they have to come together. And to your final question, Karthik, while the jury is out, there would definitely be at least some of the other organizations looking at a probable constitutional challenge.
All right. Well, we will, of course, keep a track on that story. But thank you so much for joining us. That's all we have time for. Kapil Chaudhary, partner Denton's Link Legal. Thank you so much for adding so much clarity to this very, very complex subject.
Thank you, Karthik, for having me. It's a pleasure.
And with that, we will slip into another very short break. But coming up on the other side, you would have definitely heard of ByteDance, the makers of TikTok. Have you heard of the new tool they've launched called Dance and what it is doing for Hollywood recreations? We'll tell you all about that on the other side of the break. You're watching the AI Report.